Welcome to Business Better, a podcast designed to help businesses navigate the new normal. I'm your host, John Wright. After serving nearly 15 years as Senior Vice President and General Counsel at Triumph Group Incorporated, a global aerospace component supplier, I'm now a member of the Securities and M&A groups at Ballard Spahr, a national law firm with clients across industries and across the country. Today's episode features a discussion of the new whistleblower provisions in the Anti-Money Laundering Act of 2020. We'll discuss the types of businesses covered, who can be a whistleblower under the Act, the increased incentives now provided, new protections against retaliation, the impact of a whistleblower being involved in the conduct, and practical advice for affected institutions. Leading the discussion is Peter Hardy, a partner in Ballard's Philadelphia office, who is the co-practice leader and founder of the firm's Anti-Money Laundering Team, and advises corporations and individuals regarding allegations of various forms of misconduct, including money laundering, tax fraud, and other financial fraud. Joining Peter are Meredith Dante, also a partner in the Philadelphia office, who regularly advises clients in a broad variety of employment law matters, including whistleblower complaints and retaliation, and Diana Joskowicz, an associate in Ballard's Philadelphia office, who represents clients in a diverse array of complex litigation matters and has provided governance and regulatory advice to clients on the Bank Secrecy Act and how to prevent and address money laundering. With that, we'll turn the episode over to Peter, Meredith, and Diana.
Welcome, everyone, and thanks for joining us. This is Peter, and I'm just going to kick things off here before getting into a conversation with Meredith and Diana about this new whistleblower provision. Just kind of set the table here for a moment to remind everyone that this new law that we're talking about is part of a much larger package in the Anti-Money Laundering Act of 2020, which is a sprawling revision to the Bank Secrecy Act and other anti-money laundering and counterterrorism laws. We here obviously are going to focus today just on the whistleblower provision, but the point is there's a lot more going on, and the bigger picture is that this is definitely a focus now, even more so for regulatory and enforcement. And, you know, in terms of AML enforcement in general, in the United States, AML enforcement cases are still relatively rare. And historically, they have focused on institutions, not on individuals. That's been changing a little bit, and certainly the pace has been picking up, relatively speaking, in terms of these enforcement actions. But when they are brought, they can certainly be huge. And when we talk about the Bank Secrecy Act, it covers, quote, financial institutions. But that's not just banks. It includes a broad variety of industries, including casinos, money services businesses, cryptocurrency dealers, et cetera, et cetera. So we're really talking about a broad industry here. And when the government does bring enforcement actions that result in, you know, big dollar settlements or payouts, they typically focus on two basic things: an alleged failure to run a sufficient anti-money laundering program, and/or baked into that, an alleged failure to file suspicious activity reports as required. So certainly people have taken notice of this new law. Absolutely, the plaintiff's bar has taken notice, including across the world, not just in the United States. So there we have it for setting the table. And before I start peppering Diana and Meredith with questions, I just want to remind everyone that we have a blog, Money Laundering Watch, covers all these issues, including whistleblowers, and we invite you to check it out. So without any further ado, Meredith and Diana, first things first. Can you just tell us about this new whistleblower provision? What does it do? What does it not do?
Yeah, of course, Peter. So as you mentioned, the AMLA is part of a bigger statute. It was part of the National Defense Authorization Act, and that went into effect this past January. And as you mentioned, it includes a major overhaul to Bank Secrecy Act requirements and related anti-money laundering requirements. But what we're here to talk about today is obviously the whistleblower provision, which is aptly titled Updating Whistleblower Incentives and Protections. So this provision is significant in several respects. It expands the definition of who can be a whistleblower under the AMLA, and it also increases both the incentives to become a whistleblower and protections once one does become a whistleblower. So to start, the definition is just important, so I'm going to take a minute to read it out loud for everyone. The new definition of a whistleblower under the AMLA is any individual who provides, or two or more individuals acting jointly who provide, information relating to a violation of this subchapter or subchapter 3 to the employer of the individual or individuals, including as part of the job duties of the individual or individuals, or to the Secretary of the Attorney General. Now, that definition is significant for various reasons, one being that a whistleblower does not have to report directly to the government. A whistleblower can report simply to their employer in order to qualify under this definition. Additionally, this definition explicitly contemplates that compliance personnel can be whistleblowers. So that includes BSA and AML officers within regulatory institutions. Those people are gaining these types of knowledge about red flags. They're looking at AML failures, and they can use that type of information to become a whistleblower. So as I mentioned, there are two other aspects of the whistleblower provision that are significant, and we're going to talk about those today. That would be the incentives and the protections. And the incentives undoubtedly and unsurprisingly includes money. So now the whistleblower provision requires a mandatory reward for up to 30% of the collected amount if the government recovers over $1 million. Now that 30% threshold is significant because the previous section only provided for a reward capped at $150,000 US dollars, or 25% of the net amount of the award. To put that in context, recent AML enforcement actions, as you mentioned, have seen penalties in the hundreds of millions or even billions of dollars. I think 2020 fines exceeded $10 billion, and in the first few months of 2021, I believe regulators have already collected somewhere in the ballpark of $200 million. So that 30% is going to come into play. Additionally, this new incentive is mandatory, whereas previously rewards were discretionary. And now there is a higher likelihood that the government can reach that $1 million threshold because the AMLA also doubles the maximum statutory penalty for repeat violators of the BSA. These incentives, however, are not without their limits. Of course, the government doesn't want to give out free money. So the definition of monetary sanctions, which is what the government needs in order to reach that $1 million threshold, and it'll also impact the percentage of the award, cannot include forfeiture or restitution. And as we know, penalties for major money laundering and AML enforcement actions have often focused on forfeiture. So the fact that some of those big ticket items aren't counted towards the $1 million recovery could prove significant. Additionally, there's no floor on the percentage of an award once it's given. So a whistleblower could technically walk away with 0.1% of the award under the AMLA. And who determines that award would be the Secretary of Treasury. And so the Secretary of Treasury determines whether, to whom, or in what amount to make awards based on criteria, including the significance of the information, the degree of the assistance in the enforcement action, the government's interest in preventing such violations, and additional relevant factors the Treasury Secretary might establish. Now, disappointed whistleblowers have a narrow avenue to appeal, so they can appeal whether a award was given or not within 30 days. However, they have to satisfy the arbitrary and capricious standard in appellate court. Disappointed whistleblowers, however, cannot appeal the amount of the award. So moving on to protections, which is this other part of this provision that is really significant. And the additional protections address probably what is the core concern for whistleblowers, which is retaliation. So the AMLA provides that employers may not directly or indirectly discharge, demote, suspend, threaten, blacklist, harass, or in any other manner discriminate against a whistleblower in the terms and conditions of employment or post-employment. And those protections will apply no matter who the whistleblower reported to, whether it's their employer or the government. And I believe Meredith will discuss more on that retaliation provision later.
All right. Well, thanks for that, Diana. So you just mentioned the anti-retaliation provision, and obviously that's going to be critical. Meredith, tell us a little bit about that and how it works and maybe how it may not work.
Thanks, Peter. So the AMLA contains a broad anti-retaliation provision, and there's one key carve-out before we discuss some of the nuances related to what that provision provides, and that's with respect to any employer that is subject to certain sections of the Federal Deposit Insurance Act or the Federal Credit Union Act. So for these kinds of institutions, namely FDIC-insured institutions, the existing anti-retaliation provisions remain in effect, and these new anti-retaliation provisions that we're going to talk about today don't apply. For all other employers covered by the BSA, these new anti-retaliation provisions are quite important, and we'll talk about what is prohibited and what recourse employees will have. But what is important to note is that notwithstanding the fact that these provisions may not apply to those kinds of financial institutions, the definition of whistleblower that Diana just discussed does. So with respect to the implications for those institutions in terms of the awards potentially provided by the government, that is still very much a concern. And we've seen, expansion under the AMLA of who may be able to go to the government with what kind of information. So even if these provisions don't apply to you, it's still very important to note that we're still talking about an expanded universe of people that can be reporting to the government. But with respect to employers who are not covered by those other acts, these provisions are quite broad in that they really open the door to a variety of potential retaliation claims for a number of people working at your organization. So given the fact that the whistleblower status can apply to people who report directly to their employer or the government, in theory, you now have certain compliance professionals that may fall within the definition of a whistleblower because they're reporting information to their employer that they gained throughout the course of their employment. And then assuming they fall within that definition of whistleblower by making those complaints, they could be in theory cloaked with some kind of protection against retaliation. And that can create a variety of different issues for employers because now you have a broad swath of people, compliance professionals, who may be raising issues and compliance related concerns during the course of the day. And the question really will become, are they engaging in protected activity under the AMLA? And if so, are they then protected from retaliation in connection with raising those concerns? And you can see from a practical standpoint that it may create additional challenges for employers in issuing other performance evaluations or discipline that they may have planned on issuing with respect to people who may be in this constant state of protection, so to speak. So in addition to creating these issues for employers, the anti-retaliation provisions also lay out a framework for individuals to file complaints with the Department of Labor for retaliatory action. They can do so in the first instance, and OSHA will investigate those retaliation claims. And then there's an additional option for them to then file a claim in federal court seeking a jury trial if there's no decision from the Department of Labor within 180 days. So it's a very short time frame for individuals to be able to go to federal court with a complaint related to retaliatory behavior by their employer in connection with them raising a concern about compliance with the AMLA. So there's a variety of different recourse available for successful whistleblowers. There is reinstatement. Let's say someone was terminated potentially for performance-related reasons, but they are alleging that it was in fact related to a concern that they brought to their supervisor's attention. So they could be reinstated. There's compensatory damages. There's double back pay. So that's pretty significant, as well as attorney's fees. And whenever there's attorney's fees and fee shifting, we know that the plaintiff's bar is watching. And I will tell you that you can already see on some plaintiffs' firms' websites that they are making it very easy for individuals to engage with them about potential whistleblowing activity. They have chat functions and there are immediate responses asking about the details of any kind of potential retaliatory action. So we know that the plaintiff's lawyers are paying attention. So this is definitely something that employers are going to have to be aware of and contend with. as we move forward.
Thanks, Meredith. So there was a lot packed into that. And you touched on the fact that this covers AML compliance staff. We're going to hit that again in just a moment. I just wanted to make a few comments and then one follow-up question, which is, again, reminding everyone that the Bank Secrecy Act applies to a lot more industries than just banks. Like I said, casinos, money services businesses, and broker-dealers, by the way. And in fact, Diane just blogged on the fact that the SEC issued an alert very recently warning the public about its AML concerns regarding broker-dealers. I'll make a comment, too. I was speaking recently with somebody at the Department of Justice, and I won't name this person, but he or she is involved in this type of work and made the comment that the Department of Justice is directly getting reach outs from would-be whistleblowers. So, I think the race is on. I've one follow-up question for you, Meredith, and it's somewhat ridiculous / rhetorical, but I just want to make the point. So you said that these provisions apply from AMLA to financial institutions that are not FDIC insured. So does that mean that if I'm a bank, I can retaliate against a whistleblower?
Peter, that is a great question. And I certainly would not want to leave the audience with the impression that is okay. And the answer to that is no. There are anti-retaliation provisions that exist in the current statutory scheme that addresses FDIC insured institutions. And so those provisions very much still exist. And in fact, that is the reason why, at least in connection with the passage of these amendments, the legislative history and the comments around the passage of the amendments suggest that Congress didn't feel it was necessary to change the existing framework. So it was not as though there is not an existing framework that prohibits retaliation. There very much is. It's just that these specific amendments, which are a bit broader in some respects, do not apply to those FDIC insured institutions. So to your point, Peter, no, it is still very much I would say, poor business practice to retaliate against individuals who raise certain complaints. However, the definitions under the prior statutory scheme are a bit more narrow. But in general, best practice is not to retaliate against anyone who engages in any kind of protected activity in raising complaints to the government.
Indeed. Okay, thanks for that. Okay, so you all have done a great job here kind of setting out the new provision. When people think of whistleblowing to the government, a lot of people think of Dodd-Frank. How does this new provision compare to Dodd-Frank?
Yeah, that's a great question. So it's kind of well known at this point that this provision was modeled after the Dodd-Frank. They saw the success that the Dodd-Frank gave the SEC in these types of whistleblower programs. And so I think that they're hoping to replicate that success. For a little color on that, since issuing its first award in 2012, the SEC has issued more than $500 million in awards to whistleblowers. And those enforcement actions associated with those awards have resulted in more than $2.5 billion in recovery. So that's not a small sum to look at. And I think that that's what's the driving force behind some of this. So the AMLA is similar to the Dodd-Frank, and it differs in several respects. Under both statutes, so there's similarities, multiple whistleblowers can receive a shared award of up to 30% of the recoveries exceeding $1 million, as well as recoveries from related actions by other government entities, foreign and domestic. Additionally, whistleblowers may supply information anonymously as long as they are represented by an attorney. A little known fact, whistleblowers do not have to be insiders. They may receive awards based on their independent knowledge or independent evaluation of publicly available information, as long as the government is not already aware of the information. So there is a provision in the AMLA that information provided must be original information. That goes to the fact that the government doesn't already know what's going on. Additionally, whistleblowers are not required to be U.S. citizens or residents, but can include foreign nationals and individuals living abroad. As long as there is a sufficient nexus to the United States, the predominant illegal conduct does not have to take place in the United States. And additionally, under both statutes, whistleblowers are generally entitled to protection from retaliation by their employers based on their reporting of violations. So the AMLA does have several differences than the Dodd-Frank, some of which may actually impact the success of the program, but that yet remains to be seen. So the AMLA does create a separate program targeted at foreign corruption, which doesn't necessarily appear in the Dodd-Frank. The AMLA definition, as we've mentioned before, includes compliance personnel, in contrast to the Dodd-Frank, where while key compliance personnel may be eligible to receive awards, there are restrictions on their eligibility. And as I mentioned before, the AMLA does not institute a floor on the percentage of award that a whistleblower may be provided. This is a significant point because under the Dodd-Frank and relatedly under the IRS's whistleblower program, there are floors on the percentages of awards. So whistleblowers are guaranteed money. For context, Dodd-Frank sets a 10% award floor and the IRS sets a 15% award floor. So those mandatory 10%, 15% awards, those are incentives. Whereas under the AMLA, there's a lot more uncertainty as to what a whistleblower is going to come out with, and that might impact their incentives. And finally, unlike the Dodd-Frank, the whistleblower will receive retaliation protections even if they don't report to the government. They can go directly to their employer. Under Dodd-Frank, retaliation protections only apply to whistleblowers who report to the government rather than internally.
Got it. Thanks. So, as both of you have mentioned, the new provision explicitly applies to anti-money laundering compliance staff, and in some banks you're talking about hundreds, if not more, people. This seems like a key point in your views. What are the potential implications of this?
So, unfortunately for employers, the implications are great. This inclusion of compliance personnel kind of creates this interesting dichotomy for regulated institutions, and it's one that employers certainly should be aware of. When you really think about it, on one hand, compliance officers are required to test for potential red flags, and through the course of their work, they may require actual knowledge of compliance failures. Failure to act on that knowledge can lead to individual and corporate liability. On the other hand, willful ignorance of these red flags or compliance failures can also lead to liability. So there arises this delicate balance of deciding how much attention or due diligence is enough in each instance. And when you couple that tension with pressure from the fact that government enforcement actions have more recently focused on compliance professionals, that could be a recipe for an overly defensive compliance officer or even a whistleblower. And when you add in the mix the variable of whether top management or the board is listening to failures that are raised up the ladder, compliance officers are put in a little bit of a precarious position, and they need to be, looked after their concerns as well. Some may become actual scapegoats. Some may just feel like they're becoming a scapegoat. That dynamic can further push them in the whistleblower direction. This all goes to say that companies clearly should pay attention to red flags and take whistleblowers seriously.
Right. I mean, there's a lot going on there in all of the group and individual psychology, and I just take a moment here to share a case. You mentioned, Diana, individual liability, and although it is true that to date most AML enforcement cases have focused on institutions, not individuals, there are certainly instances where individuals have been held liable. And, regardless of the head count, if you will, it's my perception, which could be wrong, that some compliance people, particularly if you're higher up in the org chart, are worried, themselves. They are a little nervous and resent the fact that they could be in the crosshairs because it is their job to ensure compliance. And there's one case that, is kind of a perfect storm of this. I'm just going to summarize at very high level, but I invite the listeners to consider how this case would play out now in light of these enhanced whistleblower awards. And so a couple of years ago, there was a major bank that underwent an enforcement action, and so did its former chief counsel. And how it came about was the chief compliance officer had identified, in their view, serious deficiencies, and allegedly, management had disregarded this. Meanwhile, the Office of the Comptroller of Currency, which was the AML examiner for the bank, began, their exam, as they always do. And so to try to deal with these deficiencies or the allegations of deficiencies, the bank, as many corporations do, contacted had an independent assessment of their AML program by an outside consultant. And allegedly, this outside consultant corroborated the concerns of the chief compliance officer. So what happened? Well, the chief compliance officer became a whistleblower and actually took the report and gave it to the OCC. Meanwhile, in the view of the OCC at least, the bank's response did not sufficiently disclose the existence of this report and instead disputed the findings. And, in my view, that's something that a bank has a right to do. You don't need to necessarily roll over, but there were a lot of other things going on. It wasn't just this report. I mean, there were some fundamental AML deficiencies in the background here. I don't mean to minimize it, but the upshot is because the OCC felt that it had been misled, it actually ended up undergoing an enforcement action against the former chief counsel, who had allegedly misled the OCC. So here you have this combo of individual liability, literally, and a compliance officer who is, not happy, and becomes a whistleblower. And, hundreds of millions of dollars later, when you're talking about the bank itself, there you go. And I put it out there as a cautionary tale, if you will. But again, that was before this law came into effect. So for whatever it's worth. Okay, so switching gears here then, what if the putative whistleblower is complicit in the underlying conduct? What then?
So that's a great question. And I think as our guest bloggers, Mary Inman and Carolina Gonzalez of Constantine Cannon mentioned in our blog on the AMLA whistleblower amendments, the legislative sponsors of the FCA noted that it takes a rogue to catch a rogue. And I think that that's something that we've seen many times before in the whistleblower context. And one of the most notable instances being Bradley Birkenfeld. So it does present an interesting question when you have a whistleblower who is involved in the underlying problematic criminal illegal activity.
And Bradley Birkenfeld here, sorry to interrupt you, being a former UBS banker who was at the center of the massive enforcement action by IRS and DOJ regarding undisclosed offshore accounts. That's the Mr. Birkenfeld to whom you refer?
Yes, that would be the one and only to who I refer. And that, certainly that's an exceptional case. But nevertheless, we see it at varying levels of complicity. Now, the AMLA does exclude from whistleblower status individuals who have been convicted of AML violations for the conduct that would have been subject to their award. So there is a carve out for individuals who are convicted of the same conduct that they bring to the government's attention that would be the subject of an award. However, practically speaking, and Peter, definitely weigh in given your experience here, if someone comes forward and gives the government a extremely strong case, and maybe they have some level of culpability, but not a high level of culpability, from a practical standpoint, there's a good chance that that person is not going to end up being convicted of the underlying conduct, especially if they bring to the government's attention a large scheme of potential violations under the AML. And so I'm not sure that this exclusion here is really going to be a big disqualifier for most people, even if they had some level of involvement in the underlying problematic conduct. What are your thoughts?
I agree with that. I mean, putting my old hat on as a federal prosecutor, and every case is different, et cetera, et cetera. Yeah, I think if somebody comes to the government and they have a juicy case on a silver platter, my prediction is that many prosecutors, consciously or unconsciously, will come up with all sorts of good reasons as to why they don't want to prosecute this person. Now, two caveats to that. It's easy for me to say that, but of course, I suppose if you're the actual whistleblower going into the situation and you don't know how it's going to come out, it might give you pause. And also, too, in terms of, again, back to Birkenfeld, and just according to public documents filed by the government, the problem that he had with the government wasn't that he came in and was complicit in the scheme. Rather, it's he came in and, according to the government, lied about his complicity in the scheme. That's why they prosecuted him. That's why he went to prison. But he also got $100 and some plus $million. So there's that.
Yeah. Yep. Absolutely. One of those stories for the books. One thing to note, though, in addition to that, is that you can presume that the complicity, though, may affect the discretionary decision regarding the percentage of the award. So, Peter, you mentioned, maybe it would give them pause in coming forward, but perhaps coupled with the anonymity that Diana mentioned, people may have some level of comfort, and perhaps it really would then just be a measure of how much would they be entitled to if they had some level of involvement versus being excluded entirely and potentially facing criminal charges. So yeah, that's what we have to say about complicity.
Okay, so maybe we'll just kind of wrap it up here and do big picture. In light of all of this, folks, any practical advice for financial institutions?
Yeah, I think that there's a lot of advice that I think that comes out of these amendments, and a lot of it's, I think, relatively low-hanging fruit. And so many studies show that whistleblowers typically report things internally before resorting to reporting to the government or some other kind of external body. So, and I think from data from the SEC whistleblower program, 84% of the employee whistleblowers who received awards had actually raised their concerns internally first before bringing their concerns to the SEC. That's a pretty significant percentage, 84%. So what that says is that many employers here who are covered by the BSA are going to have the opportunity to try and address these concerns, and may be able to do so in a way that prevents individuals from feeling like they have nobody else to turn to but the government. So the first thing is make sure your processes and procedures in place for reporting these kinds of violations are not only in place, but that you've reviewed them, you dust them off, that employees are familiar with them, that they are trained on them. And it's a good idea now, now's as good a time as any to do refresher training. And maybe to the extent that there are certain revisions that need to be made to make it easier for individuals to report their concerns, make those amendments now. The more that you can address these concerns internally, obviously, the better position you're in. The second piece of advice is to take whistleblowers seriously. We heard from our guest bloggers that a lot of who represent whistleblowers, that a lot of their clients come to them, and they're almost what they call inadvertent whistleblowers, people who didn't set out to make a statement, who didn't set out to go to the government, who didn't set out to receive some massive payment, but were actually trying to do the right thing and raising concerns about conduct that they felt was improper. And so take these people seriously, take their concerns seriously. And that also goes back to the processes and procedures, making sure that there are avenues for these individuals and that the way in which the organization addresses these concerns is appropriate and prompt. So I think those are two very important things, and the training to go along with it is really important as well. From an anti-retaliation standpoint, we talked a lot about the broad coverage of these new anti-retaliation provisions and how the fact that this now can include so many compliance personnel in such a way that they may be cloaked in protection, so to speak, very often. It will be very important that supervisors work with HR and legal before taking any adverse action against these individuals. Documentation will be more important than ever. It's always been important to document all of your decisions with respect to your personnel, but now more than ever, terminating someone for performance reasons where there's no documentation of performance reasons, yet that individual has been elevating concerns to their supervisors, now creates an added risk. It creates an added potential private cause of action. So be mindful of that and make sure that your HR teams are well versed on these provisions and know what to look for before engaging in any kind of adverse action with respect to these individuals who may be who may fall within the definition of whistleblower, just frankly by doing their own jobs. So those are, I think, are some of the key pieces of advice, takeaways that I would say financial institutions should consider in response to these new amendments.
Okay, well, thank you for that. And there is just a lot going on here in this space. I want to thank everyone for listening to this. I want to remind you again, just in case you missed it, we have a great blog, Money Laundering Watch, and we also have a great labor and employment group. And obviously, we have Meredith and Diana here, two fabulous lawyers in that group, both of whom also happen to be part of the Anti-Money Laundering Team. So if you happen to run into these issues, you know where to go. So thanks a lot, everyone, for listening, and hope you found this useful.
Thanks again to Peter Hardy, Meredith Dante, and Diana Joskowicz. Make sure to visit our website, www.ballardspar.com, where you can find the latest news and guidance from our attorneys. Subscribe to the show in Apple Podcasts, Google Play, Spotify, or your favorite podcast platform. If you have any questions or suggestions for the show, please email podcast@ballardspar.com. Stay tuned for a new episode coming soon. Thank you for listening.